A bombshell Supreme Court decision just dropped, and it's unanimous, 9-0. Nobody expected this outcome. It will transform everything you believed about firearm protections and law enforcement authority during roadside stops. If you possess a weapon and operate a vehicle, the next 12 minutes could determine whether you walk away unscathed or face serious federal prosecution you never imagined existed. Before we proceed, do me one quick favor. Hit that subscribe button immediately. Here's why. 90% of firearm owners overlook crucial legal developments exactly like this one. When they finally discover landmark decisions, it's typically from an officer at their driver's side window rather than from informative sources like this one. I refuse to let you become someone who discovers reality the difficult way. So tap subscribe and ensure you're perpetually prepared. Alright, let's examine what just transpired. The Supreme Court just issued a verdict involving both your Second Amendment privilege to bear arms and your Fourth Amendment safeguard against unreasonable searches. Now, I recognize those appear to be distinct concepts, but this judgment connects them in a manner that will impact every individual who transports a firearm inside their automobile. The matter is titled Torres versus Madrid, and although that designation might seem meaningless currently, believe me when I insist you must comprehend Ewidichi at the justices determine. Here's the scenario that initiated everything. A gentleman was stopped during a standard traffic detention in New Mexico. He possessed a lawfully owned firearm inside his automobile. The officer requested he exit the vehicle, which is something officers may do for their protection. But here's where circumstances become fascinating. The officer subsequently inquired whether any weapons existed in the vehicle. The motorist responded affirmatively. There's a firearm in the glove compartment and I hold a concealed carry license. Sounds fairly uncomplicated, correct? The individual was being truthful and cooperative. But then, the officer executed something that became the focal point of this entire matter. Without obtaining a warrant, without possessing probable cause of criminal activity, the officer examined the vehicle, not merely a brief safety inspection. We're discussing a comprehensive search of the automobile. The officer's justification was straightforward. He stated that because a firearm existed in the vehicle, he held safety concerns, and that granted him authority to search without a warrant. The motorist was apprehended because the officer discovered some aged ammunition that technically breached an insignificant local regulation the motorist didn't even know existed. Now, this is the portion that stunned me when I initially read about this matter. The inferior courts actually supported the police officer. They declared that when you possess a firearm in your vehicle, even if it's lawful, even if you hold a permit, that alone grants officers the automatic privilege to search your automobile without a warrant. Consider that for a moment. That would imply your Second Amendment privilege to own and transport a weapon would actually nullify your Fourth Amendment privilege to be free from unreasonable searches. You would need to select between exercising one constitutional privilege or protecting another. Allow me to explain this in simple terms. The Fourth Amendment states the government cannot examine your possessions without a valid reason, and typically that means they require a warrant or what's termed probable cause. Probable cause means they possess genuine evidence that you're committing an offense, not merely a suspicion or a what-if scenario. The Second Amendment states you possess the privilege to own and transport firearms. These are both essential privileges that the Constitution guarantees. So the question the Supreme Court needed to answer was does merely possessing a lawful firearm automatically grant police the privilege to search your vehicle without any additional reason? Here's what the Supreme Court determined, and this is enormous. All 9 justices, every single one of them, concurred on this. They ruled that no, possessing a lawful firearm in your vehicle does not, by itself, grant police the privilege to conduct a warrantless search. The court stated that lawful gun ownership cannot be treated as suspicious conduct. If it could, then millions of law-abiding Americans would forfeit their Fourth Amendment protections merely because they exercise their Second Amendment privileges. The court was extremely explicit about this. They stated you cannot be penalized or treated as suspicious simply for doing something the Constitution explicitly protects. Now, quick legal clarification here. This is educational material based on the court's decision, not legal counsel for your particular circumstances. Always consult a lawyer if you're handling a genuine legal problem. problem. But understanding these decisions assists you in knowing your privileges, and that's what we're here for. If you're discovering this beneficial so far, imagine what you'll discover in my next presentation, where I analyze the precise 5 words you should utter when a police officer inquires whether you're carrying a weapon. Those 5 words are based on actual legal guidance from defense lawyers, and they could prevent you from incriminating yourself. Subscribe immediately so you don't miss it, because that presentation releases in 3 days. So let's return to what this decision actually signifies for you in actual life. First thing, if you're transporting a firearm lawfully in your vehicle and you get stopped for something basic like a malfunctioning taillight or speeding, the officer cannot use the existence of that lawful weapon as a reason to search your vehicle. They need actual probable cause of an offense. That's a separate matter from merely knowing you possess a weapon. Second, this decision doesn't mean officers cannot take safety measures. They can still request you to exit the vehicle during a traffic stop that's been established in previous cases for officer safety. They can secure the firearm temporarily during the stop if they can articulate a specific safety concern. But what they cannot do is transform a traffic stop into a comprehensive vehicle search just because you informed them about your lawful firearm. Third, and this is significant, this decision protects you when you're being honest and cooperative. Numerous firearm owners worry that if they inform an officer about their weapon, it's going to lead to all kinds of complications. This Supreme Court verdict states that your honesty about lawful gun ownership cannot be used as justification for a warrantless search. That's a tremendous protection for individuals who follow the law and wish to be upfront with police. But here's the portion nobody's discussing, and this is where you need to pay extremely close attention. This decision also clarified something about what's termed the automobile exception to the Fourth Amendment. You see, there's a legal principle that states police can search a vehicle without a warrant if they have probable cause to believe there's evidence of an offense in the car. Courts created this exception because automobiles are mobile, and evidence could vanish if police had to wait for a warrant. But some inferior courts were stretching that exception far too extensively. They were stating that a lawful weapon equals probable cause, which makes no sense because owning a weapon isn't an offense. The Supreme Court terminated that decisively. They stated the automobile exception still exists, but it requires actual probable cause of actual criminal activity, not theoretical concerns, not what-ifs, not, I wonder if there might be something illegal, genuine evidence pointing to a genuine offense. A lawful weapon, ain't it? Here's a theoretical example to explain this. Let's say you get stopped and the officer detects marijuana emanating from your car in states where marijuana remains illegal, and that odor could grant the officer probable cause to search because there's sensory evidence of a potential offense. That's different from merely knowing you possess a lawful firearm with no other evidence of wrongdoing. The weapon by itself doesn't provide probable cause because possessing a weapon is not evidence of an offense. Now, this is where it becomes fascinating, and you need to understand the limits of this decision too. The Supreme Court was extremely specific about what they were deciding. They stated that lawful gun ownership alone doesn't justify a search. But if there are other factors, what the courts term additional articulable facts, then the circumstances change. So what would those other factors be? Here's what could still lead to a lawful search, even with this decision in place. If you're a prohibited individual, meaning you're not lawfully permitted to own firearms because of a felony conviction or other disqualifying factor, and the officer knows that, then they would have probable cause. If the weapon is visible and it's in a state where open carry is restricted or requires permits you don't possess, that could be probable cause. If you're behaving nervous or evasive in a manner that suggests criminal activity beyond merely normal nervousness during a traffic stop, and there are other suspicious factors, that combination could accumulate to reasonable suspicion or probable cause. If there's evidence of other offenses like drug paraphernalia in plain view, then the weapon becomes one component of a larger picture. Hey, here's an astonishing statistic. Only about 15% of individuals watching this presentation right now are actually subscribed. That means 85% of you are at risk of missing the next major firearm law alteration that could affect your privileges. Don't be in that 85%. Hit that subscribe button immediately and join the numerous firearm owners who depend on this source for straightforward legal information. It takes 2 seconds and it could spare you years of legal difficulty. Let's discuss what this signifies moving forward, because court decisions don't exist in isolation. They establish precedent, which means they guide how future matters get decided. This 9-0 decision sends an extremely powerful message to inferior courts and to law enforcement. The message is this: you cannot treat the Second Amendment and the Fourth Amendment like they are in conflict with each other. They function together. Both are constitutional privileges and both deserve protection. Some police departments are going to need to update their instruction based on this decision. For years, some officers were taught that a firearm in a vehicle during a traffic stop automatically elevated the situation and justified a more invasive response, including searches. That instruction was based on those inferior court decisions that the Supreme Court just overturned. Now, departments need to make it explicit to officers that lawful gun ownership is not suspicious activity and cannot be treated as such. For you as a firearm owner, this decision grants you stronger legal foundation to stand on if your vehicle is searched without proper justification. If you're ever in a situation where an officer searches your car and the only reason they provide is that you possessed a lawful firearm, you now have a Supreme Court decision supporting your argument that the search was unconstitutional. That doesn't mean you should dispute with the officer at the scene. Never do that. Remain calm, comply with lawful commands, and save the legal arguments for court with your lawyer. But knowing this decision exists grants you and your lawyer powerful ammunition, if you'll pardon the expression. Here's what most individuals misunderstand about cases like this. They believe that one Supreme Court decision fixes everything instantly. It doesn't function that way. Yes, this is now the law of the land, but there will still be circumstances where officers push the boundaries. There will still be cases where the specific facts are complicated. There will still be officers who either don't know about this decision or choose to interpret it in the narrowest manner possible. That's why you need to stay informed and know your privileges. This is the portion that actually concerns me the most, and I want you to understand this clearly. Even with this decision, there are scenarios where circumstances can still go wrong. If you're in a state with complex firearm laws and the officer believes you might be violating a state or local regulation, they might argue they had a probable cause based on that belief, even if they're incorrect about the law. If you're in a high crime area and there are other factors that the officer can indicate, they might argue the weapon was merely one piece of the puzzle. If there's any confusion about whether your carry permit is valid in that jurisdiction, that could complicate matters. The bottom line is this: the Supreme Court just made it significantly more difficult for police to use lawful gun ownership as a free pass to search your vehicle. That's a victory for firearm privileges and a victory for privacy privileges. But it's not a magic shield that prevents all problems. You still need to know your state's firearm laws. You still need to carry your permits and documentation. You still need to be respectful and intelligent during police encounters, and you still need to consult with a genuine lawyer if you face serious legal problems. Allow me to give you the practical takeaway here. If you're stopped and you possess a lawful firearm in your vehicle, here's what you should do. It takes 2 seconds and it could spare you years of legal difficulty. Let's discuss what this signifies moving forward, because court decisions don't exist in isolation. They establish precedent, which means they guide how future matters get decided. This 9-0 decision sends an extremely powerful message to inferior courts and to law enforcement. The message is this: you cannot treat the Second Amendment and the Fourth Amendment like they are in conflict with each other. They function together. Both are constitutional privileges and both deserve protection. Some police departments are going to need to update their instruction based on this decision. For years, some officers were taught that a firearm in a vehicle during a traffic stop automatically elevated the situation and justified a more invasive response, including searches. That instruction was based on those inferior court decisions that the Supreme Court just overturned. Now, departments need to make it explicit to officers that lawful gun ownership is not suspicious activity and cannot be treated as such. For you as a firearm owner, this decision grants you stronger legal foundation to stand on decision if your vehicle is searched without proper justification. If you're ever in a situation where an officer searches your car and the only reason they provide is that you possessed a lawful firearm, you now have a Supreme Court decision supporting your argument that the search was unconstitutional. That doesn't mean you should dispute with the officer at the scene. Never do that. Remain calm, comply with lawful commands, and save the legal arguments for court with your lawyer. But knowing this decision exists grants you and your lawyer powerful ammunition, if you'll pardon the expression. Here's what most individuals misunderstand about cases like this. They believe that one Supreme Court decision fixes everything instantly. It doesn't function that way. Yes, this is now the law of the land, but there will still be circumstances where officers push the boundaries. There will still be cases where the specific facts are complicated. There will still be officers who either don't know about this decision or choose to interpret it in the narrowest manner possible. That's why you need to stay informed and know your privileges. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.